Good day to you and welcome to another Paddocks Club video tutorial. Today we're going to deal with practical questions that arose in the discussion forum and which I believe need a wider audience in regard to sectional title noise nuisance. So let's start off with the fundamental one. What constitutes a noise? What is a disturbance? A noise is defined as a loud or unpleasant sound, particularly one that causes disturbance. The follow-up questions are there different types of noises that can be acceptable and others unacceptable? At what level does an audible noise change and then become a noise? At what is the maximum permissible limit if measured by a noise meter in decibels, which is acceptable and which will not constitute a noise? Well, the answer to these is yes, there are noises that are acceptable and others that aren't. I'm not an expert on noise levels, but if you investigate your local municipality noise pollution bylaws, you will find specifically stipulated decibel levels which are considered to be acceptable in a residential housing context. Higher levels will generally be considered by the courts, for example, to be a nuisance. So if you can hear your neighbor speaking, the TV playing or the hi-fi playing, or perhaps can hear the dog continuously barking, does this constitute a noise, and is it a nuisance? Well, in the context of high density housing, the fact that you're able to hear your neighbors' activities does not in itself constitute a nuisance. In other words, people are not entitled to expect absolute silence, even in low density housing environments. But if noise is sufficiently audible of an annoying nature and persists for such a length of time that it constitutes an unreasonable interference with the neighbor's peaceful use and enjoyment of their property, then this will be considered a nuisance. Right. People have different tolerance levels. If 4 out of 5 people are happy with the noise levels, is the fifth person's complaint valid or not? Well, the standard applied is that of a reasonable, not an over-fussy person. One cannot complain about the noise because one has a particular medical condition or other sensitivity to what is in fact ordinary noise. Another question is complexes such as ours of house rules, perhaps conduct rules. If a complaint is lodged but does not comply to the house or conduct rules, is the complaint still valid? Well, I suggest you should be careful of rejecting any complaint merely on the basis that it doesn't comply with some formula laid out in house or conduct rules. Treat it as valid and investigate. If a person makes a noise only once a year, for whatever reason, can he be prosecuted? Well, in general terms, a nuisance is considered to be an ongoing disturbance. So a person who has one loud Christmas party, for example, each year, is unlikely to be held to be causing a nuisance unless the volume and duration of that party of the noise from that party is so substantial that neighbors cannot be reasonably expected to put up with it. At feast and festival times, neighbors must expect more noise, and they must put up with that. Are there different stages of transgressing noise levels that can lead to prosecution? And what are these stages, if any? Again, look to your local municipality noise pollution regulations for details of the stage, the volume at which noise is considered to be a breach of those regulations. At this stage, and with the proof in hand, you can certainly contact the police and ask them to intervene. You could lay a charge if it were ongoing. Thank you very much for joining me. If you have any further questions, let's deal with them in the discussion forum.